Yes. The claimant counsel in court. Registrar, did you send hearing notice to the claimant counsel?
Yes, my lord.
Registrar.
Yes, my lord.
Yes,
Yes, my lord.
Yes, did you send hearing notice to them?
Yes, my lord.
Was it acknowledged?
Yes, my lord. It was acknowledged.
It was acknowledged.
Yes, my lord.
Honorable Court. Friday, Enawaji holding the brief of Oluwatosin Adesoye for the claimants.
Friday who? Friday who? I did not get the surname.
Friday, Enawaji. Enawaji spelled E-N-E-A-W-A-J-I, holding the brief of Oluwatosin Adesoye for the claimants.
Okay, good. Okay. So this is the judgment of the court. This originating summons which is taken out by the claimants for the determination of all the questions, issues as contained on the face of the originating process, and also seeks the following reliefs. Release 1 is a declaration that upon Pengasson adopted on the 16th of December 2022 and the disciplinary procedure under Rule 2 thereof, the CWC of Pengasson cannot dissolve the EXCO of any branch without the approval of NEC. In the body of the judgment, I have all the declarations sought. There are 24 of them. So I'll just go straight to the harmonized facts. This action, designated as suit number NICN LA 214/2025, was commenced by originating summons, filed on the 26th of August 2025 by Sunday Ebulu and 6 other concerned members of the Chevron branch of Pengasson against the association, its national president and general secretary, and the members of a caretaker committee appointed to run the branch. The dispute arises from a sequence of administrative and disciplinary measures taken by the national leadership of the first defendant. Following a vote of no confidence passed on the branch chairman, who is the 11th defendant by the Chevron branch EXCO on 12 September 2024, the CWC of Pengasson dissolved the branch EXCO and the chapter executive committees on the 8th of October 2024, subsequently appointing an 8-member caretaker committee. The first defendant further revoked the Chevron branch bylaws on the 10th of February 2017 and issued new election guidelines on the 30th day of July 2025. The claimant's grounds is that the national organs thereafter extended the caretaker committee's tenure beyond the constitutional limit, unilaterally revoked the Chevron branch bylaws of February 2017 as reviewed in 2022 and issued centralized election guidelines on 30th of July 2025. Leaves to nullify these actions, set aside the CTC appointments and preserve their democratic franchise. The litigation escalated dramatically when, despite the service of the electoral process, the defendants went ahead to conduct the branch delegates and executive elections on the 16th of September 2025. This prompted the claimants to file an affidavit of fact on the 17th of September 2025, urging the court to set aside the election as play on the court. The defendants, on the other hand, have resisted the suit through a 50-paragraph counter affidavit asserting that the dissolution was a necessary response to administrative paralysis and operational chaos, that the action was subsequently ratified by NEC, and that the branch bylaws were lawfully revoked due to non-submission for mandatory national revalidation. In line with rules of court, the claimant filed a written address and raised 2 issues for determination. Same with the defendants. They also filed their written address. I'm not going to go into all that, but it is in the body of the judgment. When you get it, you can look at them. So I'll go straight to the court resolution. So in evaluating the evidence in this matter, this court is guided by the well-settled principles governing the burden and standard of proof in civil proceedings as enacted under section 131 and to 134 of the Evidence Act. The standard of proof is on the balance of probabilities, requiring the party who asserts a fact to adduce more convincing and credible evidence than the adversary. In this originating summons, the claimant bear the primary burden of proof to establish through cogent and compelling affidavit and documentary evidence that the dissolution of Pengasson Chevron branch, BCom and CCom, the constitution and subsequent tenure extensions of the 8-member caretaker committee, the revocation of the Chevron branch bylaws, and the conduct of the election on 16 September 2025 were unconstitutional, ultra-virus, and void. Conversely, where the defendants assert positive facts such as the evidence of a state of emergency, operational paralysis at the branch, the non-submission of the branch bylaws, proceeds to them to establish those facts by preponderance of evidence. Now to the crux of this matter. To discharge this burden, the claimants relied on the affidavit evidence of one Sunday Ebulu, the first defendant designated as CW1, who deposed in the affidavit in support of the originating summons, and the affidavit of fact dated 17th of September 2025, and also the further affidavit deposed by one Ete Oyeg Bandren, the second claimant CW2, and the following documents were tendered, Exhibit A to P. They are all in the body of the judgment. The defendants, on the other hand, in no position to the claim, they relied on a counter affidavit deposed by one Femi Abimbola Esquire, a legal practitioner in the law firm representing the defendants, whom this court designates as DW1. He also tendered exhibits PENG1 to 12C. The claimants through these actions as concerned members of Pengasson Chevron branch who are affected by the combination of successful activities and actions affecting the vested legal rights in Pengasson Chevron branch. To start with, parties are in agreement that Exhibit A, which is the Constitution 2022, is the ground norm of the first defendant, Pengasson. Secondly, by the provisions of the Constitution, a branch may make administrative regulations or bylaws for the smooth running of its internal affairs. Thirdly, during the tenure and leadership of the second defendant, as a branch chair, the bylaw was duly submitted to the National Secretariat of Pengasson, and the bylaw was revised with the endorsed signature of the third defendant. This was tendered at Exhibit B and B1. Consequently, a new set of a Chevron BCom was elected in February 2023, and their tenure was to run to February 2026. The 11th defendant was elected as branch chair. The third and fourth defendants were elected as branch assistant secretary, and branch industrial branch chair was retained as branch ex officio. This crisis started sometime in September 2024, where the branch executive council passed a vote of no confidence on the branch chairman, who is the 11th defendant, by a vote of 12-1 vote against for removal of the branch chair, and this resolution was duly communicated by the substantive BEC to the General Secretary of Pengasson via a letter dated 13th of September 2024. It turned out that the repercussion of that request was a notice of dissolution of branch executive committees and chapter executive committees, and an 8-member caretaker committee was constituted for the branch and chapters of Pengasson, of Chevron Pengasson. Now, the claimants are in court seeking a declaration or seeking declarations that a proper construction of the Constitution and dispatch procedure under Rules 2, the CWC cannot dissolve the executive branch, the committee of the branch, without the approval of NEC of Pengasson. Therefore, the purported dissolution of BCom and CCom is unconstitutional, null and void, and of no legal effect whatsoever. They are also seeking order setting aside the purported dissolution of the BCom and chapters in October 2024. Upon reading the processes filed, this court distills that the first issue for determination is whether, having regard to the provisions of the Constitution, was the 3-man fact-finding committee constituted to investigate the disturbing report from the branch, as stated in paragraph 22 to 25 of the counter affidavit, properly constituted, whose recommendation led to the dissolution of the BCom. Having made a request in Schedule 2 of Exhibit A, to be conducted by the 5-member ethical grievance and disparate committee, which must afford the affected officers a fair hearing, including a 14-day notice of any charges against them. The defendants in their defense have argued and denied that the vote of no confidence was not appropriately passed in accordance with Schedule 2.61 and 2.62 sub 1 of the Constitution, which provides that the branch chairman and branch secretary can only be removed by the ZCom in session. In other words, the BEC/BCom cannot remove a sitting branch chair. On this submission, the court agrees with the defendant on the strength of section 2.62 sub 1 of Exhibit A. However, it should be noted that the letter of September 13, 2024, addressed to the GS of the Union that started this crisis was a letter requesting for ratification or request ratification. I think it's important the GS of the removal of the said branch share constitutional provision, that is section 2.621. This court noted that the defendant, rather than activate the constitutionally mandated procedure in Rule 31 on discipline and Schedule 2, which provides for constituting a disciplinary committee, in bracket grievance and disciplinary committee, which is empowered to hear and determine the charges while affording the person an opportunity to be heard before recommending appropriate action, failed to take this step. The national body, upon recommendation of the three-man committee, dissolved the BCom and CCom. The question now is, can this three-man committee substitute for the constitutionally designated disciplinary body? The fact-finding committee and its report was the basis of the dissolution of all the organs in the branch, that is the branch and the chapter leadership, whereas the Constitution only makes provision for dissolution of BCom. Schedule 2.6.3 of the Constitution provides that, I quote, the entire elected branch officers can only be removed from office by branch delegates conference / a special branch delegates conference / conference as applicable, convened for that purpose, end of quotation. They were to have made far-reaching recommendations, state of affairs, to justify the recommendation of. It is right that when a constitution or no order must be followed, and any departure therefrom renders that act incompetent and void. Having found that this three-man committee is first and foremost unknown to this constitution, its report and recommendation are hereby set aside and declared null and void. If for a moment this court is to turn a blind eye to the recommendation of the fact-finding committee, the court has an obligation to interrogate the actions and steps taken by the Central Working Committee of the first defendant. Did it act within its constitutional boundaries when it dissolved the democratically elected leadership of the Chevron branch on the 8th of October 2024 and constitute a caretaker committee, as well as examine its composition and extended tenure? The organic branch binding the members of the first defendant is its constitution. It resolves disputes. In resolving disputes of this nature, the law requires the court to look strictly at the provisions of the Constitution of the association, as the Constitution represents the terms of the contract which the members have voluntarily entered into and agreed to be bound by. The power of the CWC to suspend or dissolve a branch exco is not absolute. It is a qualified power subject to strict constitutional conditions. Rule 31.2 of Pengasson Constitution 2022, which is Exhibit A, explicitly provides that the CWC may suspend or dissolve the exco of any branch in accordance with the rules of this Constitution and the procedure in Schedule 2, subject to the approval of NEC. The defendants averred that another factor that informed the decision to dissolve the BCom SECOM was a receipt of a complaint from the Director HR and Medical of Chevron Nigeria Ltd in a letter dated September 11, 2024, marked as a Peng 3 and captioned request for a meeting on the unwholesome situation created by BCom, which was said to have impacted negatively in the company's business operations as well as its ability to address critical matters affecting employees' welfare and well-being. This court is appalled that the first defendant, under the leadership of the second and third defendants, who have risen to the height of president and GS of a celebrated senior staff association, such as Pengasson, could subscribe to a letter from the Director HR and without any evidence of, and I quote, unwholesome situation created by BCom, rely on the receipt of such a letter to dissolve a branch and a chapter exco. This speaks volumes of the tenacity and capabilities of the GS, who is expected to be a seasoned labor leader, the chief administrator and accounting officer of the union. In Nigeria, the courts have strictly prohibited employers from interfering in the information, administration, management, and activities of trade unions. The independence of trade unions from employers' control is protected through constitutional, statutory, and international legal frameworks. As established, Section 40 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, Section 9, Sub 6 of the Labour Act, LFN 2004, and under Article 2 of the ILO Convention number 98, Right to Organize and Collective Bargaining Convention of 1949, which Nigeria has ratified. This legal framework are designed to ensure workers and employers organizations enjoy adequate protection against any acts of interference by each other. The NICN consistently protects union autonomy. Any employer intervention that seeks to compromise the independence of a trade union constitutes an unfair labor practice and is actionable. Having taken the decision to dissolve, the defendants claim that the said dissolution of Chevron, Becom, and SECOM was deliberated upon and approved by the CWC and ratified by NEC respectively as contained in the minutes of NEC meeting held on 3rd of December now has to be interrogated. An evaluation of the record reveals sharp, irreconcilable conflicts in the affidavit evidence. While the claimant's witness C1, CW1, and CW2 assert that the dissolution was executed without the mandatory fair hearing procedures in Schedule 2 of the Pengaston Constitution and without prior NEC approval, the defendant's deponent DW1 relies on post-facto ratification. This creates a critical constitutional ambiguity as to whether a fundamentally void administrative act can be retroactively validated by subsequent NEC resolution. Furthermore, there is a direct documentary contradiction regarding the status of the branch bylaws. The defendants claim the branch failed in Exhibit O series, indicating that they were indeed transmitted to the GS. Finally, the records present conflicting versions of the NEC meeting minutes of 3rd December 2024, with the claimant's draft minute Exhibit N2 showing no deliberation on the branch dissolution and the defendant's final minute Exhibit PENC 4 claiming formal ratification occurred. These conflicting accounts form the core of the controversy which this court is saddled with. Still on this thorny issue of whether the dissolution of Chevron Branch Executive Committee BECOM complied with Rule 31.2 of Pengaston Constitution, CW1 and CW2 deposed that no disciplinary procedure was followed under Schedule 2 after the letter from BEC Branch Executive Council to the Union, all bodies for ratification of the removal of the B branch chair, and no prior NEC approval was ever obtained. Now, DW1, on the other hand, relied on Exhibit PENC 2, the report of the 3-man fact-finding committee, and Exhibit PENC 4, which is the purported NEC meeting of 3rd December 2024, to argue that the CWC dissolution in October 24 was validly ratified. The defendants also averred in their defense that on the 1st of October 2024, in Kigali, Rwanda, the CWC at the emergency CWC meeting deliberated and resolved to dissolve the BECOM and SECOM, which culminated in the issuance of the 8th of October 2024 letter to the DHR of Chevron, intimating them of the dissolution of the BECOM and SECOM. All that the defendants have averred and want this court to believe does not point to the fact that NEC approval was obtained before the letter of 8th of October 2024, which dissolved the BECOM and SECOM, was issued. The Constitution is unequivocal on the CWC's power of dissolution. It strictly provides that, and I quote, subject to the approval of the National Executive Council. This approval is a condition precedent to the validity of the dissolution. See Rule 31.2 of Exhibit A. The records reveal that the CWC issued the letters of dissolution Exhibit E on the 8th of October 2024, which was addressed to management, the Director HR and Medical, whereas the NEC meeting where this action was purportedly discussed did not take place until the 3rd day of December 2024, as shown in Exhibit PENC 4. It is not in doubt that this approval came about 3 months after the dissolution. Upon the combined reading of Rule 31.2 and Schedule 2 of Exhibit A, this court finds that the CWC's power to suspend or dissolve a branch executive committee is strictly, and I quote, subject to approval of NEC and must be in accordance with the schedule of the procedure in Schedule 2. The procedure in Schedule 2 mandates an investigation by 5-member ethical grievance and disciplinary committee, which was never constituted. Instead, the defendant set up an ad hoc 3-man fact-finding committee, which is entirely alien to the Constitution. Furthermore, the dissolution was executed on the 8th of October 2024, before any NEC meeting was held to approve it. From the evidence before this court, the subsequent NEC meeting did not take place until the 3rd of December 2024. The substance of all this submission is that management was informed of the resolution of CWC to dissolve Beacon/SECOM on 8 October. No resolution of the CWC dissolving or sanctioning the dissolution of the Chevron, Beacon, and SECOM was ever communicated to the substantive Chevron, Beacon, or SECOM officers by the first to the third defendant. While the NEC on 3rd December 2024 ratified the CWC's prior dissolution, thereby retrospectively validating it from the date it was done, and the substantive chairman of Chevron Beacon, who is the 11th defendant, upon whom a vote of no confidence had been passed on by BEC, was appointed a member of the said caretaker committee to run the affairs of Chevron Pengasson. Therefore, the CWC note acted without the mandatory condition precedent to NEC approval, rendering the dissolution of Tavares at the time it was done. The doctrine of ratification cannot retroactively validate an act that was fundamentally void ab initio for failure to comply with the statutory or constitutional condition precedent. Consequently, the claimant's version is more credible as it aligns strictly with the literal provisions of Exhibit A. This is the finding of this court. The defendant averred that their CWC action was ratified is legally untenable and represents a profound misunderstanding of the doctrine of ratification. Ratification can only apply to an act that was merely irregular or voidable. It can never validate an act that was fundamentally void ab initio for failure to satisfy a mandatory constitutional condition precedent. Because the CWC lacked the unilateral capacity under Exhibit A to dissolve the branch organs of 8th of October 2024 without prior NEC approval and without following the Schedule 2 procedure, each act was a complete nullity from its inception. I so hold. The law is also clear that you cannot ratify a nullity. The classic principle of law on this point was laid down by the court in McFoy and United Africa Company Limited, where it was held that, and I quote, if an act is void, then it is in law a nullity. It is not only bad, but incurably bad. There is no need for an order of the court to set it aside. It is automatically null and void without more and of no effect, and every proceeding which is founded on it is also bad and incurably bad. You cannot put something on nothing and expect it to stay there. It will collapse. Applying this principle, since the dissolution of 8th of October 2024 was void ab initio, there was nothing in existence for the National Executive Council to ratify on the 3rd day of December 2024. The purported ratification was an exercise in futility. This court is convinced that the CWC therefore proceeded to dissolve the Chevron branch executive organs without obtaining the proper approval of the NEC, which is against the constitutional provisions. Consequently, Release 1, 2, 15, and 16 is hereby granted. Release 3 to 6 are for declarations that a proper construction of Rule 13.4 of the Constitution, a caretaker committee constituted to administer the affairs of a branch following the dissolution of its branch executive committee cannot lawfully consist of more than 5 members. Therefore, the 8-member caretaker committee constituted in October 2024 by the CWC for the administration of the affairs of Pengasson Chevron branch is unconstitutional, null and void, and of no effect whatsoever. That the tenure of a caretaker committee constituted to administer the affairs of a branch cannot lawfully extend beyond a maximum period of 3 months. Therefore, the purported extension of the tenure of the 8-man caretaker committee by CWC beyond 3 months and for a period extending over 9 months from October 2024 is unconstitutional, unlawful, null and void. Reliefs 17 to 19 are also for orders setting aside the purported constituted 8-member caretaker committee and perpetual injunction restraining the defendant from giving effect to or acting upon the purported dissolution of the Beacon and SECOM and restraining the defendant from recognizing, retaining, or continuing to act upon the purported 8-member caretaker committee for the administration of the affairs of Pengasson Chevron branch. What this court is called to determine is whether the composition and the tenure of the CTC was in line with the Constitution. In the third case, the invalidity of the dissolution inevitably dooms the appointment of the caretaker committee. Even if the dissolution had been valid, the Constitution and subsequent tenure extension of the caretaker committee were carried out in open defiance of Exhibit A. Rule 31.4 of the Pengasson Constitution states that in the event of a valid dissolution, and I quote, a caretaker committee of not more than 5 persons shall be constituted for a maximum period of quotation. The letter of appointment, Exhibit E, reveals that the defendants appointed an 8-member caretaker committee. The defendants' explanation under GW1 that only 5 of these members had held substantive portfolios while the remaining 3 were merely advisory ex-officio members, is a superficial post facto attempt to circumvent the clear numerical limit of 5 persons. The words in Rule 13.4 are clear, they are precise and unambiguous. They must be given their literal meaning and ex-officio members for the purpose of the 5-person limit. Furthermore, the caretaker committee tenure was repeatedly extended by CWC beyond the maximum period of 3 months only, keeping them in office for over 9 months, as shown in Exhibit F series and Exhibit Peng 7A to 7C. The defendants attempt to justify these extensions under the general supervisory powers of the CWC in Rule 10.10 is unconstitutional. Under the Cardinal Canon of Construction, generalia specialibus non derogant, specific provisions override general ones. Rule 31.4 is a specific self-contained provision governing caretaker committees, and its clear time limit of 3 months cannot be expanded by invoking general supervisory powers. The caretaker committee was therefore unconstitutionally constituted, and its tenure was unlawfully extended. On this issue, I find that the dissolution of the Chevron, Become, and Secom and the extended tenure of the caretaker committee are all unconstitutional, invalid, ultra-vires, and void. Beliefs 3 to 6, 7 to 19 are hereby granted. This court will now determine whether the Pengasson Chevron branch bylaws are subordinate to the first defendant's constitution, and whether the revocation of the said bylaws and the issuance of the election guidelines dated July 30, 2025 are valid and binding. This is in line with the claimant's Rule 10.2 of seeking declarations that upon a proper construction of Rule 16.3 of the Constitution of Pengasson, the CWC has no power to revoke the approved operational bylaws of a branch, and the purported revocation of the bylaws in July 2025 is unconstitutional, unlawful, null and void. Therefore, the bylaws remain valid, substituting and operational for the conduct of elections into offices at the Become and Secom of Pengasson Chevron branch. On this issue, there is no dispute that by virtue of Rules 2.1 and 16.3 of the Pengasson Constitution, Exhibit A, the Constitution is supreme, and the bylaws of any branch are subordinate to it. Any branch bylaw that is inconsistent with the provisions of the Constitution is, to the extent of that inconsistency, null and void. However, the fact that a branch bylaw is subordinate to the national Constitution does not mean it can be unilaterally destroyed, revoked, or ignored by the national officers at their whim. The power to make and operate bylaws is a right vested in the branches under Rule 16.3 of the Constitution. Once these bylaws are approved by the National Secretariat, as in the instant case, they become a binding subsidiary contract regulating the internal affairs and democratic processes of the branch. That is the Chevron branch bylaws of 20 February 2027, reviewed and approved in 2022. A careful examination of Exhibit A reveals that the National Secretary is only blessed with the power to approve branch bylaws. It is nowhere given the power to unilaterally revoke or abolish it in their entirety. Under the guise of regulatory review, the National Secretariat issued a circular on 8th of July 2025, Exhibit Peng 9, purpose to review the Chevron branch bylaws. On the critical issue of whether the Chevron branch bylaws were submitted for review and subsequently revoked, there is a sharp and fatal contradiction between the parties' evidence. DW1 deposed in paragraph 31 of the counter affidavit that Chevron, and I quote, inadvertently did not submit its bylaws for review, and therefore the National Secretariat revoked them via Exhibit Peng 9. However, the claimant's further deponent CW2 produced Exhibit O series, which contains clear, uncontroverted WhatsApp communication printout transcript from the 11th defendant, Lavin Aga Uno, then Chevron branch chairman, on 28th and 29th of July 2024. In those messages, the 11th defendant explicitly directed the branch secretary to submit the bylaws and subsequently acknowledged, and I quote, BS, thank you for sending the bylaws to the DS today, end of quotation. This documentary evidence of the WhatsApp correspondence completely demolishes the credibility of DW1's assertion that Chevron branch failed to submit its bylaws. The defendant's claim of non-submission is a manufactured excuse designed to justify an unconstitutional power grab. From the foregoing, the defendants attempted to justify this high-handed action by claiming under DW1 that the Chevron branch had failed to submit its bylaws for review and validation in line with the national directive. This justification has been completely exposed as a falsehood. Quite fascinating is the fact that DW1, being a legal practitioner who was not a member of the union and had no personal involvement in these day-to-day communications, was merely deposing to facts of which he had no personal knowledge of. Whereas CW2's evidence is direct, contemporaneous, and backed by unimpeachable digital records. Furthermore, a careful perusal of Rule 16.3 of the Pengasson Constitution Exhibit A reveals that the National Secretariat or CWC is only vested with the power to approve branch bylaws. It is nowhere vested with the power to unilaterally revoke them in their entirety. Overall, I find that while the branch bylaws are subordinate to the first defendant constitution, but the National Secretary possesses no constitutional authority to unilaterally revoke the branch bylaws. And because under the pretext of doing so was false, the purported wholesale revocation of the Chevron branch bylaw via Exhibit 10(9) was ultra-virus, as revealed in 2024, remains valid, subsisting, and binding on the parties. Consequently, it follows that the centralized selection guidelines, which sought to bypass the provision of Chevron of nomination and selection, are completely invalid. An officer of the association cannot override or under a valid and subsisting 10 to 12 and 20 to 23 are hereby granted. Decline jurisdiction and refrain from interfering in this matter on the ground that trade unions are voluntary organizations with internal dispute resolution mechanisms rely on the rule in force. While this court acknowledges that voluntary affairs, this principle of non-interference only holds water where the association acts in good faith and in compliance with its own rules. The court will not fold their hands and allow domestic organs to tyrannize their members in flagrant violation of their own organic law. The Supreme Court of Nigeria in Oshimole and Salihu, citation provided, established that once constitutional guidelines are made and agreed upon, they become binding on the respective associations and their members, and courts will not allow them to act arbitrarily or disobey their own rules. Where there is a clear breach of the constitution of an association of the members and enforce the rule of law, the dissolution of BCOM and SECOM of the Chevron branch was a grave infraction of Exhibit A, and this court had the absolute to declare void. Now to the most regrettable aspect of the defendant's conduct. During the executory injunction which had been served on them since the first day of September 2025, the defendants rushed ahead and conducted the branch delegate and executive elections on the 16th day of September 2025. This was a deliberate litigation and present the judicature with a fait accompli. The laws of this country does not permit parties to a suit to engage to a court of competent jurisdiction. The Supreme Court in the landmark case of Governor of Lagos State and Ojukwu made this principle clear, holding that once a dispute has been submitted to the court and there is a pending application before it, the court will not allow it to be tied or a decision to be preempted by any of the parties resorting to self-help. The court has the power in Damachi and INEC. The apex court reiterated that any action taken by a party during the pendency of a suit to overreach the court or render its final judgment nugatory is a nullity and will be set aside. The defendant's conduct in conducting the election on the 16th day of September 2025 in the teeth of pending judicial proceedings was an affront to the dignity and authority of this court. This court will not allow its processes to be desecrated or treated with such levity. The branch elections conducted by the defendant on the 16th of September 2025 are a complete sham, unconstitutional, In conclusion, this court Pengasson become and come by the CWC on mandatory disciplinary procedure in Schedule 2 and without the prior approval of NEC, rendering it null, void, and of no legal effect. Second, the CTC appointed by the CWC was unconstitutionally constituted with 8 members in violation of the 5-member limit under Rule 31.4. And its tenure was unlawfully extended beyond the maximum 3-month limit. Third, the Chevron branch bylaws were duly submitted for review in July 2024, and their purported wholesome revocation by the National Secretariat in July 2025 was ultra-virus and invalid, meaning the revised bylaws of February 2022 remain the only valid legal instrument regulating elections. And four, the BCD and DCOM elections conducted by the defendant on 16 September 2025 during the pendency of this suit, which excluded democratic delegate elections and allowed CTC members to act as delegates and elect themselves into substantive offices as evidenced by Exhibit F and Exhibit PENG 18, were procedural sham, unconstitutional, and are hereby set aside. I find it imperative to bring to the fore the fact that trade union elections are more than just internal administrative procedures. They are vital democratic processes where members assign authority to the individuals responsible for protecting their collective rights and interests. Therefore, union elections at all levels, whether unit, chapter, branch, zonal, or national, must be carried out transparently, verifiably, and responsibly, ensuring they are free, fair, and beyond reproach. The law does not tolerate a situation where union leaders emerge through a process shrouded in secrecy, manipulation, intimidation, procedural impropriety, or disregard of the governing legal framework. Every stage of the electoral process, from the issuance of notices, nomination of candidates, conduct of elections, declaration of results, and resolutions of disputes, must withstand scrutiny and democratic fidelity to the Constitution of the Union, fidelity to the Constitution of the Union, constitutional values, and applicable statutory provisions. Trade unions are democratic institutions. Their legitimacy derives not from the mere declaration of election results, but from the integrity of the process that produced those results. Any departure from the Union Constitution, any infringement of members' democratic rights, or any violation of the law undermines the credibility of the election and erodes members' confidence in the institution. Courts have consistently emphasized that democratic governance within trade unions is not optional. It is a legal imperative. Those entrusted with conducting union elections bear a solemn duty to ensure strict compliance with the governing rules and principles. Any election outcome, however popular or convenient, cannot be sanitized if the process leading to it was fundamentally flawed. In view of the above finding and reasoning reached, this court hereby grants all the declarations and orders in the original summons, which include declarations that the dissolution of the Pengasson, Chevron, BCOM, and CCOM by the CWC of the first defendant on 8th of October 2024 is unconstitutional, ultra-virus, null, void, and of no legal effect. 2, the appointment and subsequent tenure extension of the 8-man CTC to run the affairs of the Pengasson, Chevron branch are unconstitutional, invalid, null, and void. 3, that Pengasson, Chevron branch bylaws of 10th February 2017 as reviewed in February 2022 remain valid, substituting and binding, and that the purported unilateral revocation of the said bylaws by the National Secretariat in July 2025 is ultra-virus, null, and void. In addition, this court shall proceed to make a consequential order, which is an integral part of the judgment itself, flowing naturally and directly from the main decisions above, CSAM and CALU, and also APC and CAFI citations are all provided. A court possesses the inherent power to grant a consequential order, even if it was not specifically asked for by the parties in their pleadings. This is permissible provided the order relates to the main claim that was contested by the parties and pronounced upon by the court. See Damachi and INEC, ATM, and Ministry of Land and Physical Planning, and Buyan and Akingboyi. Citations are all provided. It is also intended to give full effect to the judgment and ensure that justice is completely served, making it clear and leaving no room for ambiguity. In other words, to ensure that the justice of the case is fully realized. It is hereby ordered, setting aside the branch delegate and executive elections conducted by the defendants on the 16th of September 2025 during the pendency of this suit, as well as any offices filled or actions taken pursuant to those invalid elections. An order of perpetual injunction is granted retaining the defendants, whether by themselves, their agents, privies, or anyone acting on their behalf, from recognizing or acting upon or giving effect to the dissolved CTC, the revoked bylaws, or the election conducted on 16th of September 2025. The first defendant is ordered to conduct fresh elections, democratic branch elections, within 30 days of the judgment in strict compliance with the Pengasson Constitution and the Pengasson Chevron branch bylaws of February 2017 as reviewed in 2022. The Southwest Zonal Director of Labor, Federal Ministry of Labor, Lagos, is to supervise the conduct of the election and forward a report to this court within 7 days of conduct of that election. Costs of these actions are awarded to the claimants assessed at 500,000 to be paid by the first defendant. This is the judgment of the court.
We're most grateful, my lord, for the well-considered judgment and nothing.
Yes, my lord. We are equally very grateful, sir. Thank you very much, my lord.
Please leave the meeting. I have another sitting. If you are for Ebulu's case, leave the meeting. I have another sitting. I have another matter. Registrar, call the next case.
My lord, the parties are about joining, my lord. We ask them not to join because you are on the Ebulu matter, my lord.
Okay.
So they've not joined. So Ibrahim is calling them to join now.
Okay then.
My lord, those for Ebulu, they are still online.
Hello?
If you are for Ebulu matter, leave the meeting.
I've sent Yeah, I've sent it. I've sent it now. Check your WhatsApp. I've sent it. Okay.
Are you ready? Registrar, are you ready for the next case? Registrar. Registrar, are you ready for the next case?
Yes, my lord. Most of the people for Ebulu, so we can't even recognize those are for the next matter now, because we still have like 9 participants or so extra.
Well, call the next case if
Okay,
the parties are there, we will know.
okay, my lord. Okay, my lord.
If you are for Ebulu's case, please leave the meeting.
Okay, my lord. Should I go ahead?
Yes, go ahead.
Okay, my lord. Resume at Lagos today, Monday, 10th August 2026, before His Lordship, Honorable Justice Damachi. You're most welcome, my lord. NICN/LA/239/2022 between Hussein Edafititi and Union Bank PLC.
Appearances?
Yes, my lord. May it please this honorable court. Faith Feso Ajanoku, my lord. Feso Ajanoku is a compound surname, sir. My humble appearance for the claimant.
Is the defendant here? Register, did you sign hearing notice and the Zoom details to the defendant counsel? Registrar.
Yes, my lord. Yes, my lord.
The defendant counsel, he's not here.
Ibrahim still called him some minutes ago now.
Hello.
My lord, Ibrahim is calling the defendant counsel again.
Hello, sir. This is
Okay.
Brian from National Interpol. So they are trying to read the judgment today, and I've sent you the link on WhatsApp. The link is now. Yes, sir. They are reading it today. My lord just called me now, and I've sent. Check your WhatsApp, sir. Yes, yes.
My lord.
Is the defendant counsel online?
My lord is joining, my lord. Ibrahim, I've called him now.
Okay, once he joins, you let me know.
Okay, my lord.
I'm online, so let me know.
Okay, my lord. Okay, my lord. My lord. My lord, it's like one more person have joined, so I don't know if it is the defendant counsel. Defendant counsel for Eda Fitz, are you online?
Yes, that's the I'm online.
Okay, okay. My lord. My lord, the defendant counsel is online. Santolo.
Good day, everyone. Good day, everyone. Okay, I'm here. I'm connected. Can anyone hear me, please?
Yes, we can hear you. Please mute yourself. Mute yourself.
Okay.
We are waiting for my lord.
Registrar, call the case so that the defendant counsel can announce his appearance. Registrar.
Yes, my lord.
Yes. Defendant counsel announce the appearance. Faith Fesu Ajanaku has announced her appearance for the claimant.
Okay. May my Lord be pleased. Lawrence Nweke. Nweke is spelled Nweke.
Okay.
My appearance is for the defendants. Union Bank of
Okay.
Nigeria.
So this is the judgment between Mrs. Edda Fetite Usin and Union Bank of Nigeria. The claimant commenced this suit by a general form of complaint, statement of fact dated 15th of June 2022, declaration by this court that its sustaination and victimization over many years, the defendant did constructively dismiss the claimant from the defendant's employment as shown by the claimant's resignation from the defendant's employment via the email dated to the sum of 852,632 naira, representing the claimant's 1 month salary in lieu of notice payable to the claimant by the defendant for constructive/wrongful dismissal of the claimant from the defendant's employment. 3, the sum of 86,000 naira for a period of 4 years at the rate of 21,500 naira per annum, had the claimant been promoted as she ought to have been to the position of a senior manager since 2016, and a sum of 50 million naira being the cumulative salary of the claimant for a period of 2 years at the rate of 25 million naira per annum, had the claimant been promoted as she ought to have been to the position of principal manager since 2020. Another awarding the sum of 120 million as exemplary damages against the defendant for the trauma, causation, and discrimination by the defendant, as well as for cutting short the claimant's otherwise promising career in the banking industry via the claimant's constructive dismissal from employment with effect from the 11th of March 2021, and cost of this suit in the sum of 5 million naira incurred by the claimant as solicitor's fees in connection with this suit. The claimant's case. This suit arises from an employment dispute between the claimant, Mrs. Esin, and her former employer, Union Bank of Nigeria, wherein the claimant seeks a declaration of constructive dismissal alongside substantial monetary claims. The claimant entered the defendant's service on the 14th day of August 2009 as the deputy manager was confirmed on the 18th of August 2010 and received the sole promotion to the rank of manager on 16 October 2012. She has saving contributions. She faced systematic career stagnation, confirmation as head of General Services of Nigeria, and an allegedly biased disciplinary process, and was suspended in September 2021 over an altercation with a subordinate. The final fracture in the relationship occurred in October 2021 when she was deployed to Abuja. A transfer she claims was punitive and executed without the necessary logistical and accommodation packages, asserting that these events and the lack of relocation package created an intolerable work environment. The claimant resigned from employment on the 24th of February 2022. At the trial, the claim is C1 to C19. They are all in the body of the document of Nigeria. The defendant, Union Bank of Nigeria, is a commercial bank registered under the laws of Nigeria and the former employer of the claimant. The defendant filed this statement of defense and accompanying process on the 22nd day of October 2022. The defendant resist the action on the ground that the employment relationship was strictly contractual and governed by the written terms of service, which contain no guarantee of promotion. The defendant maintains that promotion remains an absolute managerial discretion, and that the claimant's transfer to Abuja was a lawful exercise of administrative authority accompanied by calculated relocation allowances. It is the defendant's position that the claimant was not dismissed constructively or otherwise, but voluntarily resigned the appointment by giving 1 month notice in lieu of a contract of service, thereby this entire called Mr. Francis Idiage want to do it. The defendant's final written address and issues for determination are in the body of the judgment, so is the claimant's address. I'll go straight to the resolution of the case. By the combined provisions of Section 131, 132, and 133 rest squarely on the party who asserts the affirmative of any fact in issue. In this case, the claimant bears the primary legal burden to establish her claims of constructive dismissals, career stagnation, and entitlement to the specific monetary and declaratory relief sought. The standard of proof is on the preponderance of evidence and the balance of probabilities as mandated by Section 134 of the Evidence Act. Once the claimant makes out a prima facie case, the evidential burden shifts to the defendant to prove any defensive facts or assertions relied upon to escape liability. In the course of evaluating the evidence, CW1 testified that she was employed on the 14th of August 2009 as the deputy manager and was confirmed on 18 November 2010, which is collaborated by Exhibit C1 and C2. And via an email dated 2012, she was promoted to the position of a manager, which is evidenced by Exhibit C3. To substantiate the exceptional performance, she tendered reviews from 2017 to 2022. This document consistently 2018 appraisal Exhibit C8 describes her as the project team's quality champion and commended her ability to work without supervision. CW1 also testified that her cost-saving initiatives in general services saved the defendant over 900 million naira. She further placed reliance on Exhibit C15, which is a Central Bank of Nigeria appointment letter dated 16 April 2021 as the chairperson of the Financial Inclusion Special Intervention Working Group, and Exhibit C16, which is the defendant protest letter to CBN demanding her removal as proof of the defendant's active hostility. That throughout her 12 years of labor, she was promoted only once despite receiving consistently outstanding appraisals and implementing massive cost-saving initiatives. Under cross-examination, however, CW1 admitted that the salary figures of 21,300,000 naira and 25 million naira per annum claimed in her pleadings were never formally communicated to her by March 2022 and gave 1 month notice in line with her contract of employment. DW1, on the other hand, testified that the contract relationship between the parties was governed by D1, that's the offer of employment, D2, the confirmation letter, and Exhibit D3, the contract of service dated 17 of August 2009. He further averred that contractual right there for the claimant's confirmation as substantive head of services in 2017 was reversed because it lacked the MD's approval. DW1 also relied on Exhibit D4 and 5 ounces, totaling 1,207,000. The refusal to relocate constitutes gross insubordination. However, on the cross-examination, the credibility of DW testimony admitted that he was not directly involved in the redeployment and had no personal knowledge of what her post redeployment roles of duty would be in Abuja. He further admitted, and I quote, "I never worked in the same team as in his deposition was not before the court." Crucially, DW1 admitted that he did not know if the claimant had refused accommodation or if in accommodation in the bank in Lagos. In confronting the two competing versions of facts, the court finds several areas of direct conflict. First, the issue of career stagnation and promotion. CW1 claims she was due for promotion in 2017 and 2021 based on a stellar performance reviews, C5 to C12, while the defendant claims promotions are subject to manage by a literal construction of Exhibit D3, which contains no clause guaranteeing automatic promotions. Thus, the defendant's argument that promotion is a managerial prerogative is legally correct. However, this does not completely absolve the defendant from a promotion was arbitrarily withdrawn within the issue of a disciplinary record. The CW1 claims she was unfairly suspended for 2 weeks in September 2021, whereas D1 claims that the claimant was never suspended, referred to the Employee Assistance Program Counselor for Professional Ethics and Discipline, following an altercation one. In proof of this averment, the defendant failed to produce the minutes of the disciplinary committee meeting or any official administrative record of the proceedings, despite DW1 admitting that such record do exist. Applying Section 167D of the Evidence Act, the court presumed that the production of these records would have been unfavorable to the defendant, thereby lending credibility to CW1's assertion that the disciplinary process was hostile and punitive. On the issue of the Abuja redeployment, CW1 claimed that she was punitively transferred without accommodation and logistic packages, while DW emails in Exhibit 4 and 5 show that allowances were calculated. But DW1's admission under cross-examination that he did not know if accommodation was provided and that the allocation was the defendant's position. This supports CW1's testimony that the transfer was an attempt to frustrate the act of employment, particularly when the defendant 21 until the resignation in March 2022. There is an obvious typographical her resignation date is variously referred to as 11 March 2021 and 24 March 2022. However, Exhibit D7, which is the payment advice for February 2022, and the testimony of DW1 established that the active employment relationship continued until her formal exit in March 2022, meaning this description was a mere misdirection. On the other hand, DW1, by his own admission, did not author any of the emails, appraisals, or relocation documents and never worked with the claimant. His testimony regarding the operational environment and the specific negotiations over the redeployment package is largely hearsay, as he had no personal perspective of these events. The defendant offered no explanation under Section 39 of the Evidence Act as to why the actor supervisors, the HR managers, or makers of these documents were not called to testify. Furthermore, the defendant's contention that the workplace was convivial is directly contradicted by Exhibit C16, which shows the bank actively writing to CBN to block the claimant's professional appointment. With regards to the defense's rates, the defendant argues that the claimant's resignation was voluntary and executed under Clause 7 of Exhibit D3, which permits termination by either party giving 1 month's notice. While technically true that the claimant initiated a resignation, the concept of constructive dismissal focuses on whether the employer's conduct made continued employment practically intolerable. The unilateral reversal of a 2017 promotion, the blocking of external professional advancement with the CBN, the punitive deployment 5-month period of enforced inactivity where she was given no less or no roles or duties collectively constitute a severe breach of the implied duty of mutual trust and confidence. The defendant's defense that her inactivity was self-imposed by refusing to relocate is unsustainable because the defendant had an obligation to restore her relocation welfare package, which was active by the existence of a mortgage in Lagos, but abruptly cut off. Thus, the claimant's resignation cannot be viewed as voluntary. It was a forced response to a hostile and stagnant work environment. The first issue for determination, however, is whether from the totality of the evidence adduced before this court, the claimant has established a case of constructive dismissal against the defendant. Before resolving the substance of this issue, I must first determine the admissibility of Exhibit C9, which is a flash drive containing an audio recording of a telephone conversation between the claimant and the defendant's HR manager. The defendant objected to its admissibility on the ground that it is electronic evidence that does not comply with Section 84 of the Evidence Act, Kubo and Dixon. While the claimant tendered the certificate of compliance, the certificate failed to specifically cover the flash drive itself or the device used to make the original recording. Under Section 84 sub 2 and 4 of the Evidence Act, the admissibility of computer-generated evidence is strictly conditioned on proof of the integrity and operational state of the device at the material time. Since the certificate of compliance did not encompass the flash drive containing the copied audio file, the mandatory statutory conditions have not been met. Consequently, Exhibit C9 is hereby marked rejected and expunged from the record. The claimant testified as evidence in chief and tendered Exhibit C1 to C19 in support of the case. She testified that she was employed on 14th of August, which is collaborated by Exhibit C1, C2, and also Exhibit C3. She also deposed that throughout the 12 years back-breaking years of labor in the employment, outstanding appraisals implementing massive cost saving initiatives to substantiate the exceptional performance reviews from 2017 to 2020. These documents consistently praise their work. CW1 also testified that her cost saving initiative CW also admitted that under cross-examination, CW1 also testified that her cost-saving initiative placed reliance on C15, which is C16, which is the protest letter from the defendant to CBN. Under cross-examination, however, CW1 made critical admissions that directly impact her monetary claims. When asked whether the salary figures of 21,300,000 naira and 25 million naira per annum claimed in her pleadings were ever formally communicated to her, she admitted no. CW1 also admitted under cross-examination that she resigned in March 2022 and gave 1 month notice in line with the contract of employment. This court is now saddled with a responsibility to determine whether the defendant's conduct towards the claimant was so intolerable as to lead the law on constructive dismissal in Nigeria recognizes that they are compelled to resign or terminate their own employment. This principle, known as constructive dismissal, arises when an employee is forced to terminate their contract with or without notice due to the conduct of the employer, which conduct must amount to a breach of the employment contract. The courts have affirmed the applicability of this principle in Nigeria jurisprudence, as well as held in Mutual Life and General Insurance Ltd. Constructive dismissal occurs when an employee is forced to terminate their contract of employment due to the conduct of the employer, which conduct amounts to a fundamental breach of the contract. The law in the case of Mutual Life and EMM. Such a dismissal is always treated as wrongful dismissal by the employer. The measure of damages for wrongful dismissal, including constructive dismissal, is consistently held by the court to be the amount of money that is payable during the period of notice stipulated in the contract of employment as agreed by parties. This was affirmed by the Supreme Court in Obanya versus Union Bank. Amount of money payable during the period of notice as stipulated in the contract of employment. On the definition and scope of constructive dismissal, see also Ukoji and Standard Alliance. To succeed in this claim, the law requires proof that the employer committed a significant breach going to the root of the contract of employment or demonstrated by the contract, thereby forcing the employee to resign. Not voluntary, but was a direct consequence of a hostile, stagnant, and punitive work environment. The defendant, through DW1, countered this by asserting that the claimant resigned voluntarily in accordance with Clause 7 of its lawful privileges. To determine which position is supported by the weight of the evidence, I must evaluate the administrative history of the claimant's last years of service. First, regarding career stagnation, promoted only once to the rank of manager on the 16th of October 2012, during a 12 years of service despite consistent outstanding appraisals, and that Exhibit C5 to C12. In Exhibit C8, which is a half-year appraisal, her supervisors commended and praised her ability to work without supervision. The defendant was fervent that claims of promotions are subject to management discretion and budget. The conflict is resolved by literal construction of D3, which contains no clause guaranteeing automatic promotion. Thus, the defendant's argument that promotion is a managerial prerogative is legally correct. See Abenga and Benue State Judicial Service Commission. It is, however, on record that despite these stellar ratings, her confirmation as head of General Service in 2017 was abruptly and unilaterally reversed only 8 days after it was issued. The defendant's explanation, as stated by GW1, was that the confirmation lacked the MD's signature. The defendant, in his defense, in his evidence, also offered no explanation as to why a confirmed administrative action was reversed without any performance or disciplinary issues, or why the signature was withheld for an employee with exemplary ratings. While I agree with the defendant's argument that promotion is generally a discretionary management prerogative rather than an automatic constitutional right, the arbitrary reversal of an already communicated confirmation, coupled with decade-long career stagnation despite outstanding appraisals, indicates a pattern of unfair administrative frustration. Secondly, the claimant pleaded and tendered a professional development. CW1 tendered Exhibit C15, a letter from CBN confirming her election as the chairperson of FISIWG. In response, the defendant wrote a formal protest letter to CBN demanding the immediate reversal of the appointment. It is right that an employer owes an implied duty of mutual trust, confidence, and support to its employees. Writing a protest letter to a regulatory body to block a senior employee's professional appointment without any showing that the appointment conflicted with the bank rules or the approval or to attend the such external meeting as a representative of the defendant was obtained through fraud or misconduct is a direct breach of this implied duty. This is the mind of this court. It is the mind of this court that this action was hostile. This was a hostile act designed to suppress the claimant's career prospects outside the bank. With regards to the circumstances surrounding the claimant's redeployment to Abuja in October 2021 and a subsequent 5-month period of inactivity, these circumstances also critical. The emails in Exhibit D4 and 5 show that the allowances were calculated by DW1's admission under cross-examination that he did not know if accommodation was provided and that the relocation policy was withheld from the one's testimony that the transfer was an attempt to frustrate her out of employment, particularly when the defendant stopped assigning roles of responsibility to her in Lagos. CW1 testified that the transfer was punitive and executed without any logistic or accommodation packages, forcing her into a state of professional idleness in Lagos from October until her resignation. DW1 also testified and showed that the defendant deployed the claimant to Abuja with allowance and a refusal constituted gross insubordination. However, DW1's fatal admission completely dismantled the credibility of his defense. On the issue of a disciplinary record, CW1 also claims that she was unfairly suspended for 2 weeks in September 2021, whereas DW1 claims she was merely referred for behavioral counseling to the Employee Assistance Program for professional ethics and discipline following an altercation during a meeting on the 12th of July 2021. During trial, the defendant failed to produce the minutes of this proceeding, despite DW1 admitting that such records exist. Same was the case for the relocation policy. Applying Section 167 of the Evidence Act, it is my finding that the defendant unilaterally deployed the claimant without resolving her accommodation and welfare package, and therefore subjected her to a state of complete and forced inactivity by stripping her of all duties and roles in Lagos for 5 months, keeping a senior employee in a state of isolation and enforce idleness in a relationship. The defendant's best argument is that the contract of service D3 permits transfers and that she resigned by giving 1 month notice, which makes her exit voluntary. I must interrogate this argument. While an employer has the contractual duty to transfer staff, such transfers must be exercised in good faith and with reasonable administrative support, followed by a total withdrawal of work, is not a legitimate dismissal. An employee who is stripped of duties, blocked from external professional advancement, are subjected to arbitrary reversals of role confirmation, is not resigning voluntarily when she finally throws in a towel. Her resignation is a forced response to the employer's repudiatory breach of the implied covenant of mutual trust and confidence. Therefore, on this first issue, I find that the claimant has successfully established a case of constructive dismissal against the defendant. The second issue for determination is whether the claimant is entitled to the relief sought in a claim before this court. Having found that the claimant was constructively dismissed, the claimant seeks a declaration of constructive dismissal and 852,632 naira as a 1 month salary of notice. Having found under the first, the law treats this resignation as a constructive dismissal. In the case of constructive dismissal, the contract is deemed terminated by the employer without notice. Under clause 7 of these 3, the party terminating the contract is required 1 month salary in lieu. Since the defendant's breach constructively terminated the employment, the defendant is liable to pay the claimant 1 month salary in lieu of notice. The claimant's monthly salary at the time of a departure is established at 854,632 naira, which the defendant has not disputed. Accordingly, the declaration is granted and the claim for 854,632 naira as salary in lieu of notice succeeds and is hereby awarded. The claimant also claims the sum of 136 million representing cumulative salaries should have earned had she been promoted to the ranks of senior manager and principal manager. These claims proved in UBN and SZ, the law requires credible, concrete evidence of entitlement, not speculative calculations. Under cross-examination, the claimant made a critical admission that completely undermines these claims. Under cross-examination, CW1 admitted, no, it has not been communicated, and further said that had I been, it's an estimation. It is a settled principle of employment law that an employee cannot were never formally promoted. Since promotion is not automatic and the claimant was never promoted to the rank of senior manager or principal manager, she cannot claim salaries tied to those positions based on mere estimation of what she might have earned. Consequently, the claim of 136 million is highly speculative, lacks legal basis, and is hereby refused. The claimant further seeks exemplary damages of 120 million for victimization, discrimination, and the hostile work awarded where the defendant's conduct is malicious, oppressive, or shows a wanton disregard for the plaintiff's right. C. Lochin and Lehman, where the defendant's administrative actions were unfair and amounted to constructive dismissal, they do not meet the stringent legal threshold for an award of exemplary damages, which are typically reserved for egregious constitutional violations or oppressive government actions. However, the claimant is entitled to general damages for the wrongful termination of her employment via constructive dismissal and the unfair labor practice she was subjected to. In assessing general damages, the court takes into account her 12 years of dedicated service, her outstanding performance reviews in executive to 12, the arbitrary blockage of a CBN appointment, and the 5 months of enforced professional idleness, CUBN and AWA, to compensate her for the psychological trauma and career disruption caused by this constructive dismissal. What the sum of 5,125,000, which is equivalent to half of 12 months gross salary as general damages against the defendant. Finally, the claimant claims 5 million as the cost of this suit. The award, of course, is within the sound discretion of the court to be exercised judicially and judiciously. See Adelakun and Oyelade. The claimant has been in court since June 2022 to vindicate her rights incurring substantial legal expenses. In the circumstance, I assess and award the sum of 1 million naira as the cost of this action in favor of the claimant. On a net evidential basis, the court makes the following findings of fact: that the contractual relationship is governed by C1, C2, and D3. The claimant's claim for the salaries as a senior manager and the principal manager attained those ranks, and the figures were mere uncommunicated estimations. The claimant has also established a clear, credible, and uncontroverted pattern of career stagnation, unfair administrative treatment, and enforced professional inactivity between October 2021 and March 2022, which collectively constitute constructive dismissal in law. Overall, judgment is entered partly for the claimant and partly for the defendant. For the avoidance of that, the court hereby makes the following orders. 1, it is hereby declared that the claimant was constructively dismissed by the defendant from employment. 2, the defendant is ordered to pay to the claimant the sum of 854,632 naira, representing 1 month salary in lieu of notice. The defendant is ordered to pay to the claimant the sum of 5,125,000 as general damages for constructive dismissal and unfair labor practice. The claim for cumulative salaries as senior manager and principal manager in the sum of 136 million and exemplary damage in the sum of 120 million are hereby dismissed. The defendant is ordered to pay to the claimant the cost of this action assessed at 1 million naira only. All sums ordered to be paid under the judgment shall be paid within 30 days from today. Failing which, the entire judgment shall attract interest at the rate of 10% per annum from the date of the judgment until the entire sum is fully liquidated. Judgment is entered accordingly.
As the court pleases.
As the court
Thank you.